Hi guys, it's Kathy. I hope you're doing well. All right, Donald, time to hit the road. I hope that you have a great trip down to Tennessee. I had a really good night last night, Donald. Thank you. Thank you. Thank you. All right, we just got Fleischer today. That's all we got. Just Fleischer. And it'll be great. Here we go. Yeah, I don't hear anything either. You're right. Oh no, we don't have Fleischer. I got nothing. I got nothing. I didn't record the sound. I'm thinking. I I'm going to put a clip on and go get a I'm gonna go get a lawyer that's in trouble in Pennsylvania real quick. I'll put a different clip on until then. I don't know why it didn't download sound, but I have no sound for Judge Fleischer. Hold on, maybe the cat stepped on something. Before I do this, no.
To advise that in the event of
All
crime
right,
scene,
there's
they met
sound.
with HFD and
Just
located and
watch
planted
Fleischer while I
outside
go get a
business
different
multiple
clip.
times. Time of death is around 7:48 on the night of the incident. The interview with witness, with manager at Papa John's.
Papa John's or Popeyes?
This is I think he's just. That's just background information, Your Honor. It's in 2920 Tyndall Road, so I don't know if it's, I don't know what type of business that's close by. During his lunch break, he walked to the gas station, located directly south, and said he was in the gas station walking the beef. When he saw two males fighting in Popeye's parking lot. Said he was about 20 yards away, and described the defendant, gave a description of a black man in his 50s, gray beard, short thin gray hair, wearing a gray bucket hat, blue jeans, and a t-shirt. He described the defendant to be appearing homeless by his parents. The second individual, the complainant, saw the altercation. They were already physically fighting each other when he saw them. The defendant fell to one knee, and he continued to strike from the complainant. And said at this point, in the altercation, the complainant grabbed his neck, had a sharp wound in his eye, and you can see a large amount of blood coming out from the complainant's neck. The defendant then walked away, and the witness could see that he was holding a knife in his right hand. But 2 to 3 inch long blade. The witness went to provide aid and observed other apparent knife to the complainant's body, called 911, and the complainant died. Yeah.
Okay. We'll put them on for tomorrow here.
Information on this affidavit is true. You have a seat. Thank you.
Although he might have felony court, so like.
So, Your Honor, a little more information. So, in the DIMS on our assault bodily injury, all the DIMS said was 4,900 a chance. But they didn't drive 3 inches.
So she's saying it didn't ping on the GPS though.
Yeah, because we have Jensen 3 as the GPS exclusion. So I'm trying to look it up right now and see like.
And I'm a fourth one too. Okay.
Well, I mean, let me see how close that was to medicine.
Yeah.
What's the mother?
A small address.
This is 49 here. Either way, these are about 4.1 miles from each other,
Okay.
so he's still in the location. Yeah, it's like straight down. Yeah, Judge, even with the corrected address, it's still about 4 mile distance, so he still wouldn't be in violation. Well, from his previous, from his previous. I know that you think, for the question to Mary, do you want to want that on? I'm not sure if you bring me one that. Yeah, so I'm sure, I'm not trying to do things, something been given, you can give us a magistrate. It's in processing right now, so I don't see, I'm ready up, is that what he's told? He's no 176. You're ready to go to. Yeah, but, for that one, if they need to keep this, we can like, let them know, at least we have it live.
Hey,
It's a play, Judge, I don't know.
you ready now?
I'm ready.
What's in my office right now? Oh, my sister, I know, I'm gonna show him. That's what the cover is, but he's wearing this under cabinet. He was looking for felony investigator in the United States.
Yes.
And they asked him if the judge took place to continuity supervision.
Yes,
This is your signature right here?
yes.
Go ahead. First one's-
The fear of stuff.
What's the last name?
Sagara, Sagarra.
Thanks. All right, good morning, Mr. Zagara. Sir, you're charged with assault causing bodily injury. You're facing up to a year in jail and or a $4,000 fine. It's not the same complaining witness in the ag assault, is it?
No, it's not, it's not.
It's not, Your Honor.
I'd like to do a TRAS though. You know, I think that that's, I mean, we now have a bunch of cases. They're like violent cases. This is not a good way to go through life, man. You know, what do you think happens when you try to get a job? They pull all this stuff up. They're going to think that they're going to give you, really, the more convictions, the more cases you pick up, all you're doing is you make life more difficult than it already is. Life is difficult as it is. You rack up more convictions. You think you're making it easier?
No, Your Honor.
You now stand charged with assault causing bodily injury. You're facing a year in jail and or a $4,000 fine. You're also charged with terroristic threat. I'm assuming that the terroristic threat is going to be dismissed.
Yes,
right?
Your Honor.
So what they have offered you is a 6-month deferred. This is a type of probation that if you complete successfully, you do not end up with a conviction on your record. But you need to understand, Mr. Cigar, you give up nearly every right known to man by entering into this agreement. And if you fail at it, I will issue a warrant for your arrest. We're going to have a hearing and you're looking at an entire year in jail. Do you understand?
Yes, Your Honor, I do understand, yeah.
First thing I think that we should do is do a TRAS to see, what conditions you may need, because I don't know if this is everything that you may need. There's some kind of anger issues here that the last thing look, we just have a guy who has an assault. He just not picked up a murder case. We don't want that with you, right? So
Right.
that's why I think that TRAS is important to find any issues that we need to address. For you to complete this successfully, you must do an effective decision-making class, a 4-hour anger management class, no drugs, alcohol, 10 hours of community service. No contact with either of the complaining witnesses in this case. Give me children, Mr. Cigar.
No, sir.
Being with yourself these days.
Just
Do you have a job?
working and, yes, sir, yeah, I have a job and just,
Is it a full-time job?
yes, sir, yeah.
Okay, you must maintain full-time employment. Did you graduate from high school?
Yes, sir.
Aside from what the TRAS says, Mr. Cigar, I will make you a deal. If you do well, I'll take you off of this probation early. But if I find that you become a danger to my community, if you pick up a new case, if you test positive for anything, it's not going to go well for you. Do you understand?
Yes, sir, I do.
You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this agreement, you are stuck with this until you complete it or it gets revoked. And like I said, if you violate this probation, I will issue a warrant. I'm going to put you in jail. I'm going to bring you back out and we're going to have a hearing to see how much possible time you could be doing. And it's a lot. Do you understand?
I do understand, yes, sir.
Okay, man. Good luck.
Thank you, Judge.
Thank you. Or I'm sorry, how do you plead to the case? Guilty or not guilty?
Yeah, guilty.
I'm not going to find you guilty. I'm going to withhold that for 6 months. And then see how it goes. All right. So let's, all right. Thank you.
So I'm gonna bump it till nearer the end because we already saw the beginning. I have today's docket, but it didn't record sound. He looked high just in that 1 second.
I found a very.
We're going to do probable.
Judge, you ready for an arraignment?
Yeah.
Page 19, Nava, come on up. That's it, on the next one. We're doing that.
I have
Just
clips.
get here.
I might steal from
He was
Bill,
here earlier, Judge.
or
Good morning, Mr. Nava. So you're
I have a few clips, and then I'm either going to steal from Bill, or we're going to. We're not going to do the Pennsylvania attorney yet. It's really good, and I have to figure that one out, and it's still going on. So we might do a Michigan attorney getting in trouble.
charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney.
4/1/2025, officer observed, the defendant's motor vehicle run a red light. Officer ran the vehicle and found the motor vehicle had expired registration. Traffic stop was conducted. Defendant was identified by name and date of birth. Officers observed a strong odor of marijuana emanating from the vehicle. The defendant handed, law enforcement officers a marijuana pipe. A handgun, marijuana, and mushrooms recognized by
Say mushrooms?
mushrooms. Was recognized by the officer based on training experience, was also found in the vehicle. And that gun was found, Your Honor. The pistol was found between the driver's seat and center console, within the reach of the defendant, contained a magazine, 15 9mm round in it. In the range of that, and it is charged as possession of marijuana with the possession of marijuana as the underlying UCW.
What about the suicide?
No, sir, I only got charged with the, sorry.
It wasn't charged, no POM was charged, it was just the UCW.
I get it. Right? What about the mushrooms?
Mushrooms were not charged. Your Honor.
They weren't illegal. Oh, I'm sorry. I'm sorry.
Janava, you're on bond for a felony. You've now picked up a new case with a gun, with a whole host. Here's what we're gonna do now. Number one, I'm gonna find if there's probable cause to go forward with your case. The second thing I'm gonna do is I'm sending you now for a drug test. I wanna know what, if anything, is in your system, and then you're to come back. Do you understand?
So,
Pending what that says, we will do bond conditions. If you fail to go, if you fail to test, I will issue a warrant. Do you understand?
I'm not gonna lie, yeah.
Stop.
I'm gonna.
Don't say anything. All I want to know is what, if anything. Just take a seat for me real quick. We're going to get you out there. And then as soon as you come back, I'll have a lawyer for you as well.
Nava, right this way. Go ahead and sign the this stuff.
Thank you.
Judge, the interpreter's here for page 28. Vasquez, come on up.
Can you reach out to the MAC or Mr. Nava, please?
Yes, Judge. Police, yes. Go ahead and sit down.
Okay, are you ready?
Hey, you done your job? All right.
Who says?
Which one am I trying to? I'm confused. ¿Hablas inglés?
Vasquez.
Okay.
Andrea Vasquez.
Andrea Vasquez.
ULLOA.
Uyos.
A new case? Are we doing PC? Got it. Okay. Are you Mr. Stephen? All right. Good morning, Ms. Vasquez.
Yes.
Ma'am, you are charged with theft. You are facing up to 6 months in jail
No,
and or a $2,000 fine. We are going to do probable cause.
Oír motivos fundados, saber los motivos por qué te arrestaron.
You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present.
Just
If you cannot afford one,
me
one will be
puedes
appointed to you.
asignar uno de oficio.
Yes, sir. On April 2nd,
El 2 de
2025,
abril de 2025
officers were dispatched to a call
Oficiales.
service.
fueron a una llamada de un hurto.
Officers spoke with a loss prevention officer.
Hablaron con el oficial que estaba trabajando en la gente.
Complainants stated that
Y
they
el
observed
quejante dijo que observaron
on the defendants on video
en video
placing children's clothing
poniendo ropa de niños
and accessories
y otros accesorios
into a backpack
en tu maletín
and purse.
o mochila y en tu cartera.
Complainant said the defendant paid for her groceries,
Ahí dijiste que habías pagado para la comida,
but passed all points of sale
pero pasaste todos los puntos de venta
without paying for the clothing
Sí.
merchandise.
a pagar para la ropa.
It looks crazy. I haven't
Items that
seen
were
it.
taken
Y estos artículos que se llevaron,
were
What is this, part 6? Is that what you're at, up to?
$91 in children's clothing,
$91 en ropa de niños,
$9.98 in underwear,
no, $9.98 en calzoncillos
$39.92
y
in clothing.
$39.92
In clothing?
Men's.
en ropa de hombre
And $25.96
y $25.96 de ropa de mujer.
as well as baby accessories,
Otros accesorios para los niños
totaling $67.85
Total $65.85
for a combined value
para una combinación de valorada de
$235.
$235.
This was from a Walmart.
Esto era en un Walmart, dice.
Your Honor.
And Ms. Vasquez, I'm going to find if there's sufficient probable cause to go forward with your case.
So, hay bastantes motivos para ir adelante con tu caso.
Checking it out, Your Honor. It's pretty sure Walmart.
I am ordering you as a condition of your bond, not to go to any Walmart
Mira,
for any reason.
para ninguna
If I
razón.
find that you do, or if
Averigua.
I find that you pick up a new case, I will revoke your bond and I will put you in jail. I don't know what your immigration status
No
is,
sé cuál es tu estatus
but if you're not in this country with permission and you go to jail,
y vas a la cárcel,
immigration finds you
migración,
because they sweep it on a daily basis. They will put an immigration detainer on you. And you will be stuck like Chuck in custody
a quedar
until this
presa.
case is over, and then you get shipped off to immigration. This is the only warning that you will get.
Única advertencia que vas a dar.
Do not pick up any new cases.
No recoges ningún caso.
Don't be a danger to my city.
No seas peligro a esta ciudad. ¿Entiendes?
Because you have a lawyer, I will waive your appearance.
Un abogado no vas a tener que aparecer. Tu
He
próxima
will
vez.
tell you if and when you
Él
have
te
to
va
come
a
back.
decir cuando tengas que venir a corte de vuelta. ¿Ok?
He tells me he cannot get a hold of you.
Si él me dice que no se puede comunicar contigo o no
Likewise,
estás
I will assure-
recibiendo llamada, te voy a quitar la urgencia.
I'll have you sign a reset now.
Firmar
We'll have you take a seat in the jury box while we get your bond conditions. We'll have you sign it,
la condición.
and then after that, you'll be free to go. Right, good luck, man. Thank you. Thank you.
And Judge, we're ready for Amos.
This is Mr. Campbell? Okay. Good morning, Mr. Campbell. Mr. Campbell, you're charged with assault causing bodily injury. You're facing up to a year in jail and or a $4,000 fine. You have worked out an agreement where they're offering you 120 days in jail with credit for the 19 days that you've done.
Michael. That Doctor Who clip you sent me broke my brain 7 different ways. I watched the whole thing. And I don't even know what I was watching. It was so good though.
I see that it's 2 counts of assault, right?
Correct. One is gonna get dismissed.
Okay, so that's the agreement, as you see, it's 2
Shit,
counts of
Bill's here.
assault,
That means
one
we
will be
can't steal.
dismissed. Is this how you understand it? You need to understand that you're giving up a lot of rights by entering into this agreement today. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You also give up the right to appeal. Once you accept this agreement, you are stuck with this for the rest of your life. You need to understand that from now on, you are facing a minimum of 90 days in jail for any new cases that you pick up.
Sure.
Is this what you want to do?
Sure.
How do you plead to the offense of assault?
Good.
I'm going to find you guilty. I'll follow the agreement. I'll send you to it. Good luck to you. sir. Thank
Thank
you.
you, Judge.
Come on.
No, I didn't drink that much.
Come on.
Don't shoot the messenger.
Uh-oh.
Up here, Eric Ramos.
Vamos.
Ramos.
Counsel for
What's the word? What
I'm
happened?
sorry. The state's doing their due diligence and trying to get the surveillance tape to see if they can make the case.
So what we'll do is we'll set it for a 10-day discovery hearing. If you don't have it in 10 days, then
Thank you. Oh, yeah. See, you lead with the bad and then it doesn't, it goes smooth.
it's never bad.
No, it was bad news. Sorry.
If they don't get it,
Yes.
justice delayed, justice denied.
We're going to Colorado, all right? And we're going to see the judge with the defendants, but that's not the good part. The good part is the open mic afterwards.
Next, we're going to call Robert Louis Stevenson. Case number 25M5013. Good morning, sir. Good morning, Your Honor. Again, my name is Judge Scott. I'm the bond hearing officer this weekend. I will not be the judge of the case moving forward. It'll be handled by Judge Petotsky out there in Rifle. Again, Ms. Goldstein is our defense lawyer this morning. Do you want her to represent you for this morning's proceedings, sir? Yes, sir.
No.
Okay, I do appoint Ms. Goldstein for this morning's proceedings. Sir, in the event that you're released on bond, if you want continued representation by court-appointed counsel, you'll need to fill out that public defender application. And if you're qualified by their guidelines, they would be appointed to represent you. Do you understand that? Yes, sir. Okay, very good. Ms. Goldstein, do you waive further reading and advisement pursuant to Rule 5?
Judge, I did speak with my client. We would waive Rule 5 advisement.
Okay, so what we're going to do at this point, Sue, is we're going to determine whether we need any more protection orders and when we're going to set your bond. I'm going to first for Mr. Hershey from the people. Yes, sir.
Your Honor, I believe the defendant has another pending case. This is an allegation, Your Honor, of consumption of alcohol while on bond pursuant to his protective order. Just checking that other case. Well, he has several, but there was an indecent exposure case that was pending with a felony menacing, I believe, with Judge Neely, 24 CR 324. So the defendant is on bond in a felony matter, Your Honor. I'm going to ask the court to consider a cash surety or a low cash only bond. I am concerned about Mr. Stevenson. I'm concerned about his neighbors. I'm concerned about him personally. It's not just a condition that was just thrown in there. That was a major cause of that earlier case. So I'd ask the court to consider that in a new date with Judge Petotsky that same day. Thank you, please.
Ms. Goldstein?
Thank you, Judge. So, Judge, my client does have strong ties to the community. He resides in Parachute. He does own his own trailer, and he pays $800 a month in rent. My client is not able to work. So I understand Mr. Hershey's concerns. I would request a personal recognizance bond or alternatively a low cash only bond, perhaps $100. Thank you.
Okay, give me 1 second. I'm just scrolling. So, Mr. Hershey, were you asking for any additional protection orders or no?
No, Your Honor. This is a violation of alcohol.
Okay. So, sir, what we're going to do, these are hard cases. When we have the neighbor cases and these protection orders, they're challenging because they can add up and stack up and just keep piling on in a hurry. But at the same time, people typically have the right of quiet enjoyment in their properties and their residences. And it makes for a difficult scenario sometimes. So here's what I'm going to do. I'm going to give you one last opportunity at a PR bond. I'm going to set it at $1,000 personal recognizance bond. That means in this case, you'll be released today on your word. If you appear for court, you can be financially responsible for the $1,000. I do not know if you have any other holds. Obviously, you don't have any other holds. You have to clear those before you're going to be released. Conditions of your bond, sir. No new law violations on bond.
Rebecca. Hi. Hi, Beck. It's so good to see you.
Notify the court if you have changed to your residential or mailing address. You may not consume alcohol or controlled substances without a valid prescription. That is a condition of your bond. And having done a number of these neighbor cases, both as a judge now and as a defense lawyer, I know they can pile up, and I know that sometimes neighbors are quick to call the police, but at the same time, they have a right to do so if they're being yelled and screamed at or what have you. Right. And so, when you're not consuming alcohol and controlled substance, that is a bond condition. And if we have further cases like this, I fully anticipate that Judge Patowski will revoke your bond and you won't be having to spend a bunch of money to be able to have your liberty. We found no contacts with Wendy Maxon or Donald Boynton, that's WENDYSON, and Donald Boynton, BOYNTON, as a condition of your bond. That means no yelling across the fence, none of that stuff.
Is that better?
Sorry, you know, again, my suspicion is this is going to be the last opportunity to personal recognizance bond through, and I hope you'll take advantage of that. There's lots of assistance out there if you need help with the alcohol issue. Ask. And if that's an issue, if you want us to appoint the Bridges liaison, we certainly can do that for you.
This is I do have an appointment to go to Salt Lake City by the end of May to go to a 30-day program.
I'm glad to have the answer. All I'm saying is that if you get the urge to get angry, stay indoors. Okay?
Get down, get down,
Put yourself
get down.
in this situation. So, that,
God damn it.
that's going to be the bond condition.
Why do you
Court
keep
case hearing
knocking my,
April the
oh
21st
no, I'm not
at
muted.
8:30 a.m.
My cat
in
just
Division
destroyed
1
everything.
of the
Look.
Garfield County Court in Rifle. That sounds like you've probably been there before, so that's Judge Patowski's.
No,
courtroom.
I don't have
So,
audio. Can you guys hear me?
Mr. Hershey, anything further from the people on this case? Not in this case, Your Honor. Thank you. Okay, Ms. Goldstein?
No, thank you, Judge.
Okay, and Mr. Stevenson, do you have any questions about what we did here this morning, sir? No, sir. Thank you.
Can you hear me
Okay,
now?
Good luck to you, sir. Thank you, sir. Thank you, Your Honor. Thanks, everyone. Yep.
That's everything in the ninth. Thank you.
It is. Stick around for 1 second, Mr. Hershey.
I will.
I was just gonna say that guy represented,
Says my audio's
Wolf
off,
there
but you
for
guys can hear me.
his 12 cases. It was the series of
This is the good
and
part. Yeah, don't thank that cat. Do not thank that cat.
yeah, this all the cases.
I'll
were
leave my mic
dismissed.
on.
And so,
Right, and we still occasionally get a complaint about a protective order, and I tell the sheriff's office, you can arrest him if you want. Nothing's gonna happen, but I don't know what to tell you.
yeah, well, and I know that when the neighbor initially had
That
gone
cat.
to get a protection order, Judge Patowski denied it.
Yeah,
And then he was like a witness in a case, and so he was a protected party as a witness in a case. And that evolved into all these other cases.
Yep,
And it was
that's what I
just,
need.
it was just a cluster, but, yeah, when I read the affidavit in this case, that was the one that I was reminded of, and that's
I wish
actually,
they could all get along. I like my neighbors, they all seem very nice.
yeah. Yeah,
It's not a good way to live, Your Honor.
no, I totally agree with it. And there's always some level of mental health issues and everything else. And it's unfortunate, but it's also a tough spot. So anyway, I just wanted to thank you, Mr. Hershey, that was the case that came to me when I was reviewing the affidavit. So
No, it's very similar.
same
So that was, I just thought that was cool that he was talking about that case. So, okay. Pretend this square is my living room. All right. I stream from my living room. I stream from this little tiny little corner. Okay. And at the very edge of the corner is, I have a lot of cords. I have 3 lights, 2 monitors, the microphone, the keyboard, my headphone cords it goes to my phone. And cat has this whole room to walk around in. This whole room this cat can walk around in absolutely with no problems. But he keeps walking right here. This is where he wants to be, right here. And he just pulled out half my cords. Brr. So, all right. Let's go to this one. Nope, I don't hear it either. Hold on.
People.
762, Cindy Morrison.
Kaylee Tambridge on behalf of Ms. Morrison.
Good morning, Ms. Morrison.
Arian on behalf of people. So Judge, we have reached a resolution. I've uploaded the paperwork. It contemplates a plea to conspiracy to commit motor vehicle theft with the parties to recommend closing this with a 90-90.
Ms. Morrison, I am looking at a Rule 11 here, ma'am. I understand that you wish to enter a plea to conspiracy to commit motor vehicle theft in the 3rd degree, a Class 6 felony. Is that correct? You understand the possible penalties for that charge is up to 18 months in the Department of Corrections, a $100,000 fine. That sentence can range from 6 months to 3 years in the Department of Corrections with exceptional or aggravated circumstances and the mandatory period of 1 year of parole. You understand that? Looking at the Rule 11, ma'am, I see your electronic signature. I don't see.
This got me because when we were all growing up, Grand Theft Auto was a big deal. Like if you stole someone's, if you stole their jewelry or all their lawn furniture, or, you stole someone's stuff, you got charged with stealing. But if you stole their car, Grand Theft Auto, you go to jail for a long time for Grand Theft Auto. She stole a car.
Your electronic signature, though.
Did I not put it on there?
You did not.
That sounds like something I would do.
But nonetheless, you went over this with Ms. Morrison. Is that correct?
Yes, I did.
Is that correct, Ms. Morrison? And did you have sufficient time to go over this Rule 11 in its entirety with your attorney? Do you have any questions about your rights? Has anyone promised you anything in order to enter this plea? Anyone forcing you or threatening you to enter this plea? Are you under the influence of any alcohol, drugs, medication preventing you from entering this plea? So this is the charge of conspiracy to commit motor vehicle theft in the 3rd degree, a Class 6 felony. How do you plead? Guilty or not guilty? I'll accept that guilty plea, finding it to be entered into knowingly, intelligently, and voluntarily after a full advisement of rights and consequences by the court and for the people.
Thank you, Your Honor. We're asking the court to sentence the defendant to 90 days jail and give her 90 days of credit. We are not asking for restitution in this case. The motor vehicle in question was returned was stolen and recovered the same day. Your Honor, the reason for the 90-90 request is there is an extradition case and she needs to go to another state to resolve that. And so we believe this is an appropriate resolution. Thank you.
And her just telling the judge we want a 90-90, she might have thought that was cute, but it's not because it makes no sense. He figures it out, but no, she stole the car. They got the car back, but she stole the whole car.
90 days credit, or is it 90 days on supervised probation, 90 days jail?
So it will be 90 days of probation with the only condition of 90 days of jail. And I believe she has 90 days of credit. So all of those things together.
The only other thing I'd note about the extradition case is that it's a no bond hold. She's already waived extradition. And so really we just need to close this case out so that she can get on her way and be able to take care of that case in Texas as well. I can also tell the court that in my conversation with her regarding this case, I mean, one of the first things she said to me and one of the first things she said to the police that she knows how stupid this was. And that I think she feels really bad. I think she feels like this was a very impulsive decision that she made, but I think she's more than prepared to take responsibility for that. And I think that's something she's acknowledged from the beginning. Other than that, that's all I have.
More saying anything
They got the car back. They got the car back. She stole the car, but they got it back.
Pretty much covered it. I got some impulse control issues, but I'm working on it. And yeah, and it was a stupid mistake. But that's about it. Well, work on it.
It's more so obviously you understand that actions have consequences, right?
No, they don't.
You accept the responsibility. That's great. And I hear what you're saying about having these impulses, but you got to find a way to control them. Otherwise, this is going to be the life that you live. And I'm sure this is not what you want for yourself. Okay. What I'm trying to get at is that you can make changes. It's never too late. All right, the court will place you on 90 days of unsupervised probation, impose 90 days jail, give you 90 days credit for time served. The court will waive any waivable fees and costs. Good luck, man. For the record, there is no restitution.
Thank you.
Thank you.
Yeah, 90 days. They just want her out of there so that she can take care of her other cases. But she stole a car. She stole a whole car. All right, I'm going to try to fix this real quick. I just want to get my my camera started. Ooh, so far so good. Hold on. Got my camera started. Background. Purple. Blue. Green. I don't want none of these backgrounds. I'm not in the mood for any of them. Yeah. All right, we haven't seen this one in a while. Now, I got to stop sharing my screen. Try to get sound back without me. I need to be able to mute. I am not sitting here for 3 hours and not be able to mute my microphone. That would suck. All right, now let's see. This is a real quick one.
Sanflor versus Karina Rames, 25 CF 474.
He was denied data assets.
Hello, Ms. Raines.
Hello.
Ms. Raines, you were arrested based on an allegation of possessing a controlled substance. I find probable cause. Your bond set in the amount of $2,500. You make in excess of what the court can consider indigent for purposes of appointment of the Office of the Public Defender. So if you choose to be represented, you'll need to talk with one of our local attorneys or address that matter with your trial court. Thanks.
I have a question.
Yes, ma'am.
I have something to say.
I'm happy to hear you out. Let me give you one piece of advice. And gentleman standing next to you is an attorney. He's going to advise you that you probably should not talk about the facts of the case on the record with the state present. Thank you.
Like, no, you're not talking. No, you're not talking. I like him. I like that Florida court. if you see, like, I don't know what this is. It looks like something in outer space, the planets or something, but I know it's not. And I wonder what it is because they're in jail. I wonder what their announcements are for them in jail. Yeah. That's how I wish all the lawyers were. Like, nope, shut up. Nope, shut up. He wasn't nice. This one, this is when you do something. I think this guy probably got a harsher sentence for this next clip than she got for Grand Theft Auto.
So I was able to speak with him. He would like to accept the city attorney's offer this morning.
All right, let me pull that up briefly here.
My man is in jail. He's in jail, guys. Ready?
And then we'll have a quick conversation. Smoking in public in case number 2024-5390. If you plead guilty to that charge, the prosecution's asking that I just impose a fine, but suspend the fine, which means that you would be done with your case and there wouldn't be anything that you would have to pay. Is that what you'd like to do, sir? I couldn't hear you. Could you say that again for me, sir?
He may have to pop the video.
Yeah, officer, we may have to go off camera because we're not able to hear very well. We don't have the good video audio connection. So if the officer's there we go. Mr. Johnson, I think we're saying.
Yes, I would like to accept that offer.
Okay, thank you for that, Mr. Johnson. So when you plead guilty, you're giving up your right to trial. Do you understand that?
Trial.
Are you doing that voluntarily?
He's given up his right to trial, guys, for smoking in public.
Today?
Yes.
Is anybody forcing you to plead guilty?
No.
Are you under the influence of any medications or drugs or alcohol?
Nicotine.
No.
Do you understand this charge of smoking?
Yes, I do.
And Ms. Talene, would you waive a factual basis for the charge?
Yes, Your Honor.
All right, then how do you plead, Mr. Johnson, to the charge of smoking in public in violation
Have a nice trip, Donald.
of section 643.5 of the Boulder Revised Code occurring October 5th? That cannot be correct.
I know, that's what I said too.
I don't know if we had a motion to amend. I didn't see one.
Yes, it was. It was dynamite.
Ms. Oswald, this shows a 1964 date of violation. Did you want to make an oral motion to amend?
Yes, Your Honor, thank you. Looking at the citation, it appears that Mr. Johnson had been contacted on his date of birth, which is listed as the same as the date of offense. And so the city perceives this to be a scrivener's error, given the
city arrested him and put him in jail on his birthday for smoking.
I guess incidents of having the citation issued on the same as the date of birth. And so we'd like to make an oral motion to amend to 2024. And that would be corroborated, Your Honor, by the ticket citation number that has the 2044 at the top.
Denied. We're going to have a hearing bring the officers in so that we know the correct date of offense. We'll do it in 2 weeks. Sir, you're going to be kept in jail for 2 weeks until we figure out this error.
And Ms. Talene, any objection to the oral motion to amend?
I do not have an objection. I will let the court know that I did advise Mr. Johnson that was probably the error.
Okay, thank you for that. So I'm going to grant the motion to amend to indicate that the alleged date of violation is October 5th of 2024 at 77 Broadway. The allegation is that you committed the offense.
So the courts have held on to this case since October. He was probably picked up on a warrant for his arrest because back in October he was smoking.
Smoking in public in violation of section 643.5 of the Boulder Revised Code. How do you plead to that charge, sir?
Guilty.
I'll accept that guilty plea. Any comment from you?
He's guilty. And that other girl who stole a whole ass car got nothing. 90 days in jail, 90 days credit. But she was already in jail for another thing. So nothing. She got absolutely nothing. But she got to stand up there and say, oh, I've been caught impulse controls and I just want to take responsibility for what I've done. I don't. Yeah, that was Colorado. Don't mess around in Colorado, which is crazy because you can go ahead and mess around in Colorado with, you know, drugs and crimes because they're very, the state is more rehabilitation than punishment. So if you make mistakes in Colorado, they try to keep you on the straight, you know, get your schooling, get a job, get a house. But if you smoke or if you put a tent up in Colorado, that's it. That's like the worst thing you could possibly do. Yeah. Actually, yes. Yes. In Colorado. This one isn't the greatest clip, but you know, they all can't be great.
And I definitely.
This is Licking County. I think this is Stansbury, I think.
Keep car insurance on my car. I have a 2007 Toyota Corolla. I bought it for $2,500. Didn't think it was going to run for maybe a couple months when I got it. It had no brakes. It had transmission leak.
Now, is this the vehicle that you bought through Byrider, or is this a different car?
No, this is a different car.
Different car, okay.
It's a 2007 Toyota Corolla. It's an old car.
Did they repossess the vehicle?
Yes, they did, and they resold it.
Okay.
They resold it.
Which should have gone towards your the total amount like that you owe. So let's say they say you owe 10 grand on a car. They repo it and they sell it at auction and it brings in $5,000. That has to be credited towards the out.
It's for blind ass people like me. I need more of those little bumpers in my life because my eyesight sucks. And look, you can't bump into the judge by accident. I don't think she could drive a Flintstones car.
Standing balance and that gets reduced. So here's the thing as far as the garnishment is concerned. When a creditor, aka a plaintiff, files a lawsuit and they get a judgment, they're entitled to use certain legal means to try to satisfy that judgment. The most common are wage garnishment or bank attachment.
Okay.
For wage garnishment, they can also put liens on real property, like if you owned like a home or if you owned like a...
I don't know anything about my car.
And they could put liens on those type of things as well so that if they were ever sold, they would get some of the proceeds. But as far as today is concerned, with the wage garnishment, they're permitted to take up to 25% of your take-home pay after mandatory withholding. Now, mandatory withholding basically is taxes. So I don't think that mandatory withholding includes health insurance. Mandatory withholding doesn't include like contributions to a retirement account or anything. Yeah.
I don't
So
have it.
unless you're claiming that they're taking more than 25% of your gross pay after take-home, they're entitled to do it. It's unfortunate. We have these types of hearings quite a bit, and it's pretty common for the plaintiffs not to show up. They'll just submit paperwork instead of showing up, because I always felt that if we could get the two parties together to discuss it, that they can maybe work out an agreement. It costs them money to file the motion for the garnishment. There's what's called poundage that's involved, and that's extra money that they wouldn't necessarily have to pay if it was voluntary.
Poundage? Judge, please explain more.
And it's not unheard of for creditors to negotiate with defendants, debtors,
I know,
to say,
Kelly,
hey,
I know.
we'll agree to take this, lower that payment, but they have to agree to it. The court can't order them to. So there's two things. Number one, unfortunately, financial hardship. There are certain things that can be exempted from garnishment, or there are certain bases for that. Unfortunately, the legislature has decided that financial hardship is not one of them. So even though you can say, hey, this is really killing me financially here for them to take this out, that's not a recognized basis to cancel the garnishment. And it's not like you're telling me I don't think it should come out at all. You're just saying I need it to be more reasonable. So unfortunately, I'm going to have to overrule your objection today to the garnishment in order that continue. But the bailiff's going to take you down to the clerk's office, and we're going to get the contact information for the lawyer on the other side. We'll get name, we'll get mailing address, we'll get an email, we'll get a phone number. And you're going to reach out to them and see if you can't work out something voluntarily to where you say, look, I don't have a problem with you guys taking the garnishing my wages, but can we do it at a lower percentage? And that's not unheard of. That happens from time to time in here. I've signed off on entries where the plaintiff sends something in and says, by agreement of the parties, the garnishment order shall be modified to only withhold 20% or do a certain amount, like say $50 or $100. So we're going to get you the contact information so you can speak directly with the representatives from Byrider.
Their lawyer.
You'll probably end up talking to a paralegal, is what I would guess. Trying to think who the other side of this is. It is. Okay. The company itself is actually in Cincinnati. The law firm is actually in Cincinnati on Reading Road. It's a law firm called Sloven and Associates. They specialize in collections, so this is all they do. Most of those bigger firms that do the collections, they usually have a huge support staff, and the lawyers more often than not are just signing off on paper.
All right, guys. I don't know if you noticed, but he has these crisp corners right here. There's another one on the other side. Like, that's a professional iron job right there. That is super professional. I haven't seen a shirt ironed like that crisp since the 80s. I wonder if he does it himself.
Whereas the paralegals and the support staff do most of the work, kind of like your general manager versus you guys who actually do all the work in the store, right? Yeah. So the bad news is I do have to overrule your objection, but the good news is we're going to get you in touch with the folks on the other side of this so that you might be able to work out something voluntarily with them. Okay. Now, did you drive up this morning? Yeah. How long did it take you to get up here?
3 hours.
About 3 hours. Was traffic bad on 71? Was it? Yeah. My little sister lives down there. She's lived down there for probably about 25 years in Oakley.
So would I present this to them also?
The what?
Show them how much I pay for rent and how much I pay.
Yeah, they're probably, and that's going to be information that you're going to want to explain and say, listen, I don't have a problem paying you guys, but look, these are my monthly expenses. And when you take this much out, it really puts the clamp on me. So if you guys
I don't want to end up homeless again.
Exactly.
I was homeless for almost 3 years.
Yeah.
I had a mental breakdown and everything. So
let me ask you a question. Are you from there originally and you moved up here for a while, or are you from up here and you moved down there?
No, I'm originally from, I was born and raised here.
Okay.
But I lived in Columbus for almost 20 years.
Mhm.
And then
Moved down to
I moved to Kentucky.
Okay.
And then I moved back to Columbus.
Mhm.
And then I moved back
Back to Kentucky. All right.
So I've been bouncing around a little bit.
Do you
I
have-
had no choice.
Do you have family down there?
Family in Kentucky?
Yeah.
Yes,
Near where you live?
I have 6 children and 9 grandchildren.
Oh my goodness. Well, that'll keep you busy.
Yes.
All right. Well, Ms. Diggs, do you have any other questions today?
No,
I know you didn't get the relief you were coming here for, and unfortunately, these hearings are tough because more often than not, the creditors do have the right to do what they're doing, even though it's really creating a hardship for folks, which is why Ms. Kyle here is going to take you to the clerk's office next. We're going to get you that information. And the good news for you is if they won't talk to you, like if you're having a hard time getting through to somebody on the phone.
Terry. So they did a reverse shoulder on you. I don't know what that is. I don't want to know because it's scaring me. I don't want a new shoulder. So right now your arm is very numb, but that's going to wear off. Are you resting? Are you eating? Are you drinking? Who is helping you? Don't try to move too fast. If you push yourself before you're ready, it's just going to take you triple long to heal. Nan, tell him.
Or get your email, you can just drive up to Reading Road and knock on their door and say, hey, I need to talk to somebody about this.
Yeah.
All right. So as long as you're persistent, I think that they'll be willing to speak with you, and hopefully they're going to be willing to work with you on this because you can explain to them, look, if you guys keep taking this money, I'm probably going to lose my home. If I lose my home, I'm not going to be able to work because I won't be able to do that. And guess what? Then you guys are going to get nothing because I'll have no income. So it's in their best interest to work with you. You might want to remind them of that. Okay? Do you have any other questions today, ma'am?
I think we covered everything. You didn't look at it, but you can see how much rent
Oh, absolutely.
I'm telling the truth. I have my lease.
You know, it's funny because after we had a trial yesterday and it was kind of a he said, she said thing. And it was, who do you believe? And I always instruct the jurors. I have instructions I give the jurors about how to judge credibility. Well, I've been doing this job for close to 15 years. And before that, I've practiced law for about 11. So I've heard plenty of people talk a lot. And I'd like to think I'm a pretty good radar when it comes to people lying. You're not lying to me. I know that. Okay. Actually, the ones who lie the most? It's when they're locked up, they get picked up on a warrant and I call their name and they just start talking right away and they don't stop talking because they figure if I don't talk, then I can't keep them in jail. But it's the ones who talk a lot that make me suspicious. But I'm sorry that you're experiencing this hardship and hopefully you're going to be able to work something out with them. Okay. You have a safe trip back down to Kentucky and have a good day. Okay.
Okay. Thank you.
Court's going to stand in recess.
All right.
So I don't know why this clip is 11 more minutes. Oh, I just didn't cut it. Okay, so here's what I want to do. And I know that this causes issues. So I want to do something that I know is going to cause issues. It looks like, so like this one right here, this is an attorney that's in trouble. I have a suspicion you guys aren't going to be able to hear it. Tell me, can you hear this? Hold on. There's no sound yet, guys. Hold on. There is sound now. So to a lot of you, it'll sound muffled, underwater. Oh, can you hear it fine? No one's saying anything. Okay, that's what I thought. So for some reason on this site, some people can hear it, but the majority of people can't hear it. It sounds like underwater, which is so weird to me. I hear it perfectly fine for the latest videos. But if you go to the oldest videos, which are like 12 years ago, let me find one that's, I don't want a part 2. Part 3. Oh, she was bad. She has 3 parts. I'm looking for something that's about an hour long. And that's a good name. Chuckwara. Like Chuck. All right, you guys should be able to hear this one. No problem. There's no sound yet. Hold on. Just wait. Wait for it.
The next case on the docket is Cyril Chikora, 59938. Mr. Harris and Ms. Hamilton.
Good morning, board members. Wayne Paris on behalf of Cyril Chikora.
All right. You should have been able to hear him crystal clear. Can you hear him crystal clear? I think you can. Yeah, she was quiet. That's fine. We don't need to hear her. Her paper is louder. Yeah, people don't understand microphones. All right, here we go. Let's see what Chikora did.
Normally I don't talk too much about the background of the facts here, but I'm going to have to digress a little bit and give you a little bit of the background. Eric Hernandez was an illegal alien who was arrested and placed in custody in Houston for possession of a little less than 30 grams of controlled substance. Mr. Hernandez's mother went to see Mr. Chikora, who practiced immigration law at the time, and expressed to him that she wanted him to represent Mr. Chikora. She engaged him to represent Mr. Hernandez Eric, her son. There was a discussion between Mr. Chikura and Miss Eric Hernandez's mother. They discussed possible remedies as to how Mr. Chikura could help Mr. Hernandez. One of which item that was discussed and opined about was the possibility that since Eric Hernandez had been living with a common law lady in a common law relationship, that perhaps they could get a certificate of marriage from a justice of the peace, and as a consequence, validate his living in the United States so he wouldn't be deported. Another thing that was discussed in this conversation with the mother of Eric Hernandez was the fact that perhaps we can get some sort of rehabilitative sentence over at the state court and a deferred adjudication. Another thing that was discussed was the idea that possibly they could get a bond through the immigration court and get Mr. Hernandez out of jail, which was his immediate concern. And another thing that was discussed was possibly Mr. Hernandez might be able to be eligible for the military in order to circumvent a later deportation. All these things were discussed in the attorney-client relationship.
How's that? Am I loud?
Bond application was filed with the immigration judge. It was denied. There was a motion for reconsideration filed with the immigration judge by Mr. Chikura for Mr. Hernandez. That was set for a hearing. At the hearing, Mr.
Was
Chikura
discharged
was
as
discharged
Mr.
as
Hernandez.
Mr. Hernandez.
CJK, you just tell me what you need and I will get it.
The lawyer.
A lawyer for the Immigration Service, Donald Cassidy, heard that Mr. Chikura had come to this bond hearing and had read in a previous section of the Bar Journal that Mr. Chikura had been under a probated suspension. So he filed a complaint with the
He filed a grievance, if you will.
with the Houston Regional Office of the Chief Disciplinary Counsel and said, we've got a guy that appeared over here that got discharged by his client right in front of the judge before the motion for reconsideration could be heard. And I want to know if he still is available to practice law, because I read somewhere where he was suspended or had a probated suspension. That led to a letter from the normal letter from the Chief Disciplinary Counsel's office asking Mr. Chikura to respond to a complaint, this as a complaint. Although I don't know that that inquiry should have been classified as a complaint, but nevertheless, Mr. Chikura responded with a whole set of facts involving what I've just told you about and how he was representing Eric Hernandez. Then Mr. Cassidy, a lawyer for the Immigration Service, comes back and in a rebuttal says, well, you know, all these remedies that he suggested to his client, he's all wet about them. They just don't exist under the immigration code and the immigration laws of the United States. And the Chief Disciplinary Counsel's office used that to form that rebuttal to form a just cause letter charging violations of 101, 201, and 8.04A3. Later on, of course, after an evidentiary petition was filed, they, in fact, added 3.01. Here's the interesting factor. We all know anybody can file a complaint with the regional counsel's office. We also know that that person doesn't have to be a client. And in this case, no client filed a complaint. But we also know that when that person files any kind of a form or consisting of a grievance complaint, there's a form where you waive the attorney-client privilege. No client in this case, Mr. Hernandez.
That actually is a kind of a big deal, guys. You got to go. You got to go get your real IDs if you haven't yet, which I haven't. So if I'm supposed to have my real ID by May 7th, my best guesstimate is I will probably have it September 20th. And not a day sooner. Not a day sooner. which means I'll probably have to get on an airplane September 21st. So I'll get my real ID the day before. I'll probably miss my plane anyway. I don't want to do all this, guys. I can't do all this paperwork. It's too much for me.
Neither Mr. Hernandez or Mr. Hernandez's mother filed a complaint. Donald Cassidy is the one that filed the complaint. He was a government attorney initially. He couldn't waive the attorney-client privilege between Mr. Chikura and Mr. Chikura's mother and Mr. Chikura's and Eric Hernandez. So the reason I say that there's no, and this is a no evidence appeal, the reason I say there's no competent evidence in the record is that all of the sanctions and all of the findings of the disciplinary rule violations here are based upon an alleged discussion between Mr. Chikura and his clients, of which nobody ever waived the attorney-client privilege. Obviously, you could say, well, Mr. Chikura appeared at the evidentiary panel hearing and testified. Fine, he can't waive the attorney-client privilege for his client, and neither client appeared at that evidentiary panel hearing and testified. Now, that complaint was raised up front by his then attorney. I didn't try the case in the evidentiary panel. I came in at the time of the motion for new trial, but that complaint was raised up front, was overruled by the panel chair, and the evidentiary panel proceeded. The reason I have said that there's no competent evidence in the record is because all of these violations are based upon those alleged discussions whereby he was allegedly, or his mother was allegedly given advice, all of which are attorney-client privilege. So I don't think that there's any competent evidence that can support this position. And you'll find that on page 9 of the brief where I referred to.
Wait a second. Since when is this a symbol for support? They cannot support it. I've seen people maybe support. Okay, whatever. This was 11 years ago. Maybe the world was different back then.
The lack of the attorney-client privilege for that rebuttal letter that gives rise, if you will, to the fruit of all this poisonous tree and all the way down the line through the hearing. Aside and apart from that problematic area, let me talk about the alleged violations of the disciplinary rules that were found. What the Chief Disciplinary Counsel, the Commission for Law, Office and the Commission for Lawyer Discipline put on is evidence.
Mr. Paris, can I ask you one question? I don't mean to interrupt your argument, but I just want to make sure I understand what you're telling us. I understand that only the client can waive the privilege.
Yes, sir.
But if Mr. Chikura, on his own, for whatever reason, decides to talk about it, isn't that a matter between he and his client?
You know, if he talks about it under compulsion of having had his lawyer up front object first, and then that objection is overruled, which is in the record, that is in the transcript. I mean, up front they said he didn't want to talk about this because it's attorney-client privilege. That was overruled, and he finds himself then in an evidentiary panel situation where either he has to respond to the prosecutor's introduction of evidence, or he stands mute and is not in a defensive posture. That would be perhaps if that.
Okay. Can we all just agree? Can we just agree on one thing in America and just remove moot and mute completely from the language? Strike it dead, because nobody uses it right, and it just causes issues.
That had
Let me rephrase the question. Assume that there had been no objection by the lawyer and Mr. Chikura just went ahead and testified. Would you be making this argument then?
I would still be making the same argument, but not quite as strongly. I still don't think the lawyer could waive it for two clients that don't even show up, that are never put on at the hearing, and that have never advised him.
Whoa.
I think it's the client's
I don't think anybody would doubt that. The only question I'm asking is if the lawyer just decides to talk and We all do that, unfortunately.
Is that an implicit waiver?
I know, I don't think it's a waiver at all, but it just seems
I
to
don't
me
either.
that's a matter between the client and Mr. Chikura. It doesn't necessarily prevent it from being evidence here. That's what I'm asking you.
I think it does prevent it. I think anything that grows out of that, I've used a term we all know, fruit of the poisonous tree, if you will, but anything that grows out of that, and particularly that is the basis for these violations, because every one of these violations is based upon a supposed conversation between Mr. Chikura and his clients, and supposed advice that he gave his clients. Let me move on real quickly to the elements.
Can I ask one more question? I know you need to move on. But, what's your
yes, sir, Mr. Cruz?
What's your view of the impact of exceptions to the attorney-client privilege? Crime fraud exception, breach of duty by a lawyer to or a client. Those are exceptions to the privilege.
Yeah, and I think that if the client complains and waives the privilege, or if the client sues in a malpractice case, that's waived. But I do not think that if the client never complains, and if neither client, the mother or Eric Hernandez, never complains, then I don't think.
Excuse me, JK. I never mess up my mute button. Never. Hi, BI. I'm a professional.
It fits into an exception if for a complaint based upon that comes from a third party, if you will. I think you've got to have client input into creating an exception.
Okay, so in your view, in order for an exception to the attorney-client privilege to apply, there has to be some input one way or the other from the client.
Exactly. From as far as the basis of some sort of complaint. That's not to say that anybody can't go down there and file a complaint. We all know that. And we all know that even on an 8.04, it doesn't take an attorney-client relationship. But I do think that in order for that to be a basis, there has to be a client input into it. One of the findings was that Chikura violated 1.01A by accepting or continuing employment in a legal matter, which he knew or should have known that he was not competent to handle. I don't think that if you look at this record, and since this is a no evidence appeal, and we agree with
no, moot you.
That the substantial evidence rule applies. We agree that if there's anything beyond a scintilla of evidence, then you've got to affirm. But in this particular case, if you look at the elements of 1.01A, they just were never satisfied. The most that can be said here is that the Commission for Lawyer Discipline, if you will, called an immigration expert. Supposedly, his name was Reed Gonzalez. And another interesting factor about this was they also attempted to call Mr. Donald Cassidy, the person who had filed the complaint, who was an immigration lawyer with the government. He said, "I can't testify. I've been told by the immigration department not to come down here and give any evidence. I can't give you any opinion." Even though he'd already written a report in rebuttal to the grievance, he declined to testify. So I don't think we can look to his testimony for any basis, because he didn't testify the record, and his oral testimony when he said that is the best evidence, and not his report that was supposedly, which constituted a response to Mr. Chikura's response to grievance, a reply, if you will. Entering that into evidence is nothing more than hearsay.
Okay, lawyer, but what did your client do wrong? We need to know. It sounds like, but I don't know yet. I don't know yet. We are only, 13 minutes in, and we still don't know what's wrong. He broke attorney-client privileges, but they said violations. So the attorney did multiple things wrong, or the same thing multiple times. But they didn't say what it is yet. But I like his vocabulary. This lawyer is not annoying me. Usually when lawyers just throw in big words here and there and here and there, I get really annoyed. But I like his vocabulary. He's doing a good job, except for the moot thing.
Say if the best evidence is testimony, the guy comes before you and says, "Well, I've been told by the Immigration Service I can't testify." So in order to try to get around that, the commission calls then a fellow named Reed Gonzalez, who is in the evidentiary panel hearing, who is a supposed immigration expert. And he says, well, I don't agree with any of this advice that Mr. Kura gave to his clients. None of that works under the immigration code. None of that works under our immigration laws. There was a dispute about that. Of course, Mr. Chikura said, yes, it does. There are loopholes in the immigration code, the immigration laws. I don't profess to be an immigration expert, but at least there's a dispute about that. But here's the point. The point is, in analyzing a 1.01a violation for lack of competency, you have to show that that either Chikura possessed the legal knowledge, skill, or training reasonably necessary for the representation of Hernandez, Mr. Gonzalez, or any other evidence, or any other witness ever testified about that. So there's no evidence on that. Or you have to show that Chikura did not have the ability to acquire the training reasonably necessary for the representation of Hernandez. There's no evidence on that.
What? What did he just say? Did I hear that right? The lawyer they're trying to say he's incompetent. Like, what? Okay, I need to know what happened now.
From Mr. Gonzalez or anybody else in the record. And so, aside and apart from somebody that would have to opine as to the subjective feeling of Mr. Chikura as to whether or not he knew or should have known that he was incompetent, which almost is an inability. You can't bring an immigration expert in to say about that, because how is he going to know what's in the person's subjective feelings? So we don't think there's any evidence on that point, aside and apart from the attorney-client privilege problem. The second rule violation that was found was a 201 violation. A lawyer shall exercise independent professional judgment while representing a client and shall render candid advice while representing a client. If you look at comment number 4 to Rule 2.01, it will tell you that a lawyer's advice at best often consists of recommending a course of action in the face of conflicting recommendations by experts. So even if he had a conflicting, even if his advice was conflicted by Mr. Gonzalez, Reed Gonzalez's position that, hey, you're all wet, there's no loopholes in the immigration laws at work, then that's not a violation of the 2.01. Interestingly enough, if you look at the finding of fact on 2.01, the finding of fact says that the respondent failed to give the client straightforward advice expressing lawyer's honest assessment of the case. Well, that's the comment to 201. That's comment number 1. So what they've done is found a violation of the comment and not a violation of the rule. Obviously, we all know that comments are guidelines, but they aren't quasi-statutory like the rules are. So the finding of fact that supposedly supports 2.01 is a violation of the comment, aside and apart from the fact that there's no evidence that he violated 2.01. Let's go to the third violation that they supposedly found him to have violated, and that's 3.01. A lawyer shall not bring or defend a proceeding or assert or controvert an issue unless the lawyer reasonably believes that there is a basis for doing so that is not frivolous. Well, the only thing that Mr. Chikura filed was a bond request with the immigration court. Then he filed a motion for redetermination of the denial of the bond request, and he filed a brief in support of that. And if you look at what the finding of fact was that supposedly supported the sanction, you will find that the finding of fact says respondent attempted to bring a proceeding before the immigration court that respondent knew was frivolous and without merit, as Hernandez could not be eligible for the relief prayed for. Well, I'm sorry, but 3.01 doesn't have, we don't sanction a person for 3.01 for attempting something. So the finding of fact doesn't even support the rule. The rule says a lawyer shall not, and the finding of fact says he's being penalized and found to have violated 3.01 for attempting to do something.
Mr. Pierce, I'm sorry, I think your lights aren't working. Your first 17 minutes are up, but in light of the questions, why don't you take about 2 more minutes and then reserve what other time you have for.
Pretty fast. Thank you, Your Honor. Comment number 3 to 3.0 was one quickly says, the matter is.
Okay. How do you pronounce her name with her accent? With her Texas accent. Her name is capital J, lowercase o, capital A, lowercase l. That is her first name.
It's not frivolous if a lawyer believes such may not prevail. Even if he believes it may not prevail, and it's just a long shot. And that's exactly what it was. It was a long shot. But even Reed Gonzalez testified that if it was a long shot, and in fact,
my name is Joel.
The lawyer really believed that he is filing, what he is filing will help the client, does not violate the bar rule. The commission's own expert said that in the transcript. Finally, 8.04A3, and let me get through this real fast because this is the old catch-all rule we all know about. Conduct involving dishonesty, fraud, deceit, or misrepresentation. If you look at the few cases that have interpreted that rule, they say that conduct's got to be deceitful. It's got to lack honesty, integrity, and probity. Giving advice to your client as to the possibilities of remedies sets a dangerous standard if you're going to hold that to be deceitful, lack honesty, integrity, and probity. And so, in fact, Rule 8.04A3 is not even supported by a finding of fact in the judgment of suspension. In fact, the only thing that it can come from is giving misleading advice to the client. Again, we get back into the attorney-client privilege, and again, we get back into a situation where there's no evidence of that by simply talking about possible remedies. Thank you, Your Honor.
Sorry it took so long.
Okay, he's done. What did his client do wrong? I don't know, but he might not be competent.
Thank you. Oh, Ms. Hamilton.
Joel. I don't know what that last letter is. It looks like a capital. Joel. Is her name Joel? There's no dash. It looks just like I wrote it. I'm just calling her Can. From now on, her name is Can.
May it please the board. Good morning. This case is about a lawyer who took on the case of an immigration client who was in a dire situation, and it was a situation where the lawyer could not have reasonably believed that he was competent to represent that client. The board should affirm the judgment of partially probated suspension that was entered by the panel because there's a reasonable basis in the record for each and every finding of misconduct, and Mr. Chikора's complaints about the admission of the evidence have no merit, and they also were not preserved. The first violation found by the panel involves Rule 1.01A, which prohibits a lawyer from accepting or continuing employment in a matter when the lawyer should know that matter is beyond the lawyer's competence. It's clear from the use of the phrase "should know" in this rule that it's based on an objective standard. And it's clear from the comments in the rule that the manner in which a lawyer handles a client's case can provide very good evidence of whether the lawyer was actually competent to handle the case. In this case, the commission proved that in 1 month of representation, Mr. Chikora made multiple serious mistakes in the representation of his client. Some examples are that he believed the client was entitled to be released on bond because the client wasn't convicted of a violent crime and he wasn't a threat to national security or a flight risk. But the record establishes that exactly the opposite was true. He was not entitled to be released on bond. The order entered by the immigration court actually noted that the court had no jurisdiction in that matter. the motion for the bond hearing itself relied on case law that was more than 20 years old, even though immigration law has changed dramatically in the ensuing 20 years. Mr. Chikora also failed to recognize, and this was a critical issue, that deferred adjudication is considered a conviction for the purposes of his client's deportation proceedings. He
Ms.
also
Hamilton,
advised the client that he could
Hamilton.
avoid, pardon me?
I'm sorry to interrupt you, but is it your opinion that no lawyer could have helped this young man?
No, that's not the opinion. I think that's beyond the scope of this particular case. In these circumstances, it's a bunch.
That because, as I recall in your brief, there was some statement that this poor 18-year-old kid had gone to the lawyer and was now being deported from the only home he had ever known to some foreign country. And I was just wondering if the result would have been different had he consulted competent counsel.
Possibly the result would have been different. I can't really speak to that issue. It wasn't one of the issues in the brief, but I think that the focus, there was no focus in this case on.
These panels are allowed and they do it all the time. They interrupt, they ask questions, and they eat up their time.
On the fact Mr. Chikora's conduct, I'm sorry, Mr. Chikora's discipline needed to be enhanced because the client was deported. The results weren't really what was focused on. It was the fact that the potential results were so grave for the client, and it was so clear that Mr. Chikora did not know very much about the issues that were relevant.
Carrie, as your friend, I need to quality check to make sure the doctors gave you the right things. So if you could just send some over quick. I have a double today, so if you could get them here before I start work, that would be great.
That was the focus of the case. The commission didn't take the position that, but for what happened here, this client wouldn't have been deported. I think that would have been a difficult argument to make. It's not clear from the record whether or not that was the case, but it is very clear that Mr. Chikora didn't understand the issues that were relevant to his making a decision about whether or not he could help the client. And if it were true that there really wasn't much that any immigration lawyer could do for the client, there was a duty for Mr. Chikora to explain that to the client before he even took on the representation. Or maybe once he took on the representation, but he realized that once he learned all the facts and maybe even did some research, he realized there wasn't anything he could do there. He had a duty to let the client know that so the client could proceed accordingly. As it ended up, the client was in immigration court by himself, a teenager, 18 or 19 years old, in an immigration court by himself, facing the judge and just saying to the judge, I can't do anything here, just go ahead and deport me.
So you're saying in essence that harm to the client has nothing to do with this consideration?
In this particular case, that's right. We are not here saying that but for what happened here, this client wouldn't have been deported. He may very well have been deported, but that's not the focal point of this case.
Thank you.
Ms. Hamilton, you may be getting to this, but can you respond to Mr. Park's argument as to whether or not there would have been competent evidence, assuming the attorney-client privilege was not waived to the point that the panel or we cannot consider any evidence that came from Mr. Chikora that constitutes a waiver of the attorney-client privilege?
I think there are really two issues that are relevant to that question, and I want to make sure that I make both of these points. And the first is just from kind of a logical standpoint, that argument doesn't make a lot of sense in this context. We don't have a case where the nature of the violations shows that Mr. Chikora's supposed inability to present some information to the panel harmed him. We're talking about his competence, which is demonstrated clearly in the record. He hasn't articulated some information that he wasn't able to share with the panel that might have enabled him to defend himself better. And if necessary, and he felt like there was some evidence that was so sensitive for his client that he wanted to make very sure that it wasn't disclosed unnecessarily, he could have taken steps to do that, to make sure that that part of the record was protected. There's nothing like that here. He just sort of makes this blanket assertion that, sorry, this can't go forward because of the attorney-client privilege. If attorneys could do that, my office couldn't do its job. The commission would be hampered from disciplining lawyers because lawyers could so easily claim attorney-client privilege. In addition to that, my second point is that if you look at the disciplinary rules, particular Rule 1.05 and Rule 1.05C talks about this very issue. It talks about confidential information. It's all information that a lawyer comes into a lawyer's possession in the course of representing a client, including privileged information. And there are some exceptions, very specific exceptions to the non-disclosure requirement. And one of those is if the attorney needs to respond to in a disciplinary case, then he can do so. Still, of course, the attorney should try to honor the attorney-client privilege as much as possible and not disclose more than necessary, but an attorney can do that. Like I said, if there's something particularly sensitive, and this doesn't look like one of those cases, but if there is, he could have done that. But with the issues we're talking about, incompetence, not being frank with the court, those just aren't those kinds of issues.
Ms. Simpson, in the context of this case, where do you believe the line is crossed between malpractice and incompetence?
I don't know exactly where the line was crossed in this case, but I know that the facts in this case are so egregious that there is no question about Mr. Chakwura's lack of competence to handle this particular case. The record even shows that Mr. Cassidy, who was the chief for the Immigrations and Customs Enforcement Office in their law office, he felt so compelled by what had happened here to make this complaint, and it was something he had never done before. He'd never filed a grievance again, and that's clear from the record. Both Mr. Cassidy's letter, which was admitted without objection at any point, there was no objection to that letter, it goes into detail about all of the issues related to Mr. Chakwura's incompetence. And in addition, the expert's testimony and the expert's report also, that both went into great detail about the problems here. So based on this record, it's abundantly clear that Mr. Chakwura should have known he didn't have the knowledge, skills, and experience to represent this client in this situation.
Do you see it? I'm talking about the difference between this, like a malpractice and incompetence. Do you see that as the degree of, or the egregiousness of the error, or the number of the error, or is there some sort of temporal relationship? They have to all occur in a short amount of time? And
I think all of those issues could be factors. I think it's one of those things that you have to look at on a case-by-case basis. But yes, it could be that there are so many basic errors made, as in this case, that that incompetence is proven. It could be that the types of errors that are made are so egregious, there's incompetence. Now, the rule makes it clear that we're talking about an objective, reasonable lawyer standard. So we have to determine what would a reasonable lawyer, how would a reasonable lawyer have acted under the circumstances? And this record makes it clear, based on Mr. Cassidy's letter, based on the testimony from the expert and the expert's report, that a reasonable lawyer would have known better than to do the things that Mr. Chakwura did.
if there is no damage to the client, does that have any impact on this rule?
Damage is not the issue. Damage could be a factor in determining how aggravated the misconduct.
I mean, I guess it's a factor. So when we get we get a DUI case that didn't run over someone and kill them, but even the people who didn't get in an accident for DUI, the judges all say the same thing. You could have killed someone, blah, blah, blah. I don't know. They're still treated different than someone with a DUI who actually did run over someone and kill them. I don't know. I don't know the answer to that question here. Because, like she was saying, the result could possibly have just been the same anyway. So I don't know.
It is. It's really, usually the damage to the client is more an issue in the sanctions phase of a case than it is at the misconduct phase. But when we're talking about, for example, Rule 2.01, and that a lawyer has a responsibility to, to speak frankly with the client, and for example, in this case, to say to the client, I don't know of anything that I can do for you. I don't know a lot about these issues. You should probably hire somebody who's more experienced with this particular kind of situation. With that kind of a situation, the potential consequences to the client are relevant, because it was so important for Mr. Chakwera to honor his obligation because of the potential consequences to the client, and candidly say to the client, I can't do anything for you. Maybe somebody with more experience can.
Is that what you think is the violation of 201? Because 201 kind of puzzled me in here. I mean, I'm not sure if you look at it, counselor, advisor, and I don't know that I've seen a 201 raised. I just don't recall that. So
I think 201 was a tricky one for me too. It's not one that I've seen a lot either, but it fits this record. If you read the text of the rule itself and you read the comments and the kinds of obligations that are involved with Rule 2.01, the kinds of obligations that are imposed by the rule, I think that Mr. Chakwera's failure to give his client straightforward advice about his immigration matter, and the fact that he couldn't help him and he needed somebody more experienced because this was such a serious case, I think it is the kind of conduct that it was reasonable.
Isn't there kind of a conflict though between arguing that he's so incompetent to violate first one? If he's that incompetent, then where does his honest assessment? I mean, if he was competent and had an honest assessment that was reasonable, he has a duty to give it, but then you're arguing he's incompetent. So isn't there kind of a tension between those two? Or at least that's how I read it. It seems like a strange rule to bring.
And I think that it's not one of the issues that was raised by the parties, but I think that if that were the sole basis for the finding that he violated Rule 2.01, then maybe Mr. Paris could have questioned that. If we were trying to say solely that, okay, he was incompetent, he didn't understand these issues, didn't know anything about them, and we were then trying to say at the same time that it was dishonest for him not to give his client, tell him what these issues were about when he didn't know it, that might present a conflict. But we have the additional issue here, or the separate issue of his not being frank with the client about his own ability to do anything for the client. He not only did he not tell the client, I can't do anything for you, but he told the client, I can do all these things for you. You have all these potential avenues, when he couldn't have reasonably believed that. And so that's what I hope answers that question about any potential conflict between the 8.04A3, the 1.01A finding and the 2.01 finding.
I don't want to belabor this too much, but what is the advice he rendered which was not candid? Which is what the rule actually says. It doesn't say straightforward or honest or competent or anything like that. It says you're supposed to render candid advice, which I've always thought of as, don't just tell them what they want to hear, be candid. But that's my question. What exactly is the advice he rendered which was not candid?
Well, once Mr. Chakwera met with his client and he understood the actual facts of the case, he should have just candidly informed the client that, he didn't have the knowledge or the skill or the training to assist somebody in this situation.
But if he's that incompetent, he might not know that. He may be given the advice he thinks is candidly right. He doesn't know better.
Especially since we don't know what the client would have said if the client had testified.
And wouldn't that get you to a subjective standard at that point, that as opposed to the objective standard you've been telling us about?
Yes, that would get you to a subjective standard. And, in this current immigration this current immigration climate with this extremely rigorous standards, it just wasn't reasonable for him to walk in and present himself as somebody who was competent under these circumstances and who could assist the client in ways that were clearly not available. What the record seems to indicate is he, instead of being upfront with his client and frank with his client about those issues, he instead moved forward with the representation, presumably in order to have this client to collect this fee. And that's the kind of thing that should be prohibited by Rule 2.01.
You have about, we'll give you a couple more minutes for all the questions, but right now you have about 4 minutes.
Okay.
Just let me know,
Okay.
since your light's not working.
So we've talked a little bit about Rule 1.01A. It's clear that from the record that Mr. Chikora just lacked the basic skills to understand and handle this case. That's clear from the record, and the evidence just speaks very loudly about that issue. We've talked also about Rule 2.01 and his duty to render candid advice to his client, including telling his client, I can't help you, or I don't have the skills to even know whether there's anything that can be done for you. You should talk to somebody with more experience in this area. If nothing else, he should have known he didn't have the experience with somebody in this situation to move forward with that representation. The last two rules, 8.04A3 and 3.01, are related. 8.04A3 prohibits conduct involving dishonesty, fraud, deceit, or misrepresentation, and 3.01 prohibits frivolous filings. And the comment 3 to that rule makes it clear that a filing or contention is frivolous if it contains knowingly false statements of fact. Those violations are proven by the transcript from the immigration court, where it's clear that Mr. Chikora was not frank with the court. His client even said to the judge on the record he was not comfortable continuing with Mr. Chikora, in part because Mr. Chikora had encouraged him to lie to the court. It's clear from Mr. Chikora's answer and from his pleadings that yes, he in fact knew that the client was not married, but he represented the client as somebody who was legitimately married. There's some discussion in the brief about some kind of a common law marriage might have existed. So there might have been some basis for him to take that position, but that's not the position he took with the court. He represented to the court that the client, as if this client did have some kind of a legitimate marriage, when that clearly was not the case, and he was aware of that. He misrepresented that in 2 motions filed with the court and in the bond worksheet. And in addition, we have this very act of moving for the client's release on bond was frivolous in and of itself because there was no reasonable basis for filing that motion. So in conclusion, an analysis of this record makes it clear that the panel's findings of misconduct are well supported by the testimony of the commission's witnesses and the exhibits that were entered, only one of which drew any objection. All of the other exhibits were admitted without objection. And this record, which provides serious proof of egregious misconduct, supports the judgment that has been entered, and that judgment should be affirmed in all respects. Thank you.
Ms. Hanscom, I have one question. I just want to clarify.
Way fast enough.
Right. I just want to make sure I understand your 201 response. And is it your position that that rule was violated because Mr. Chikora did not tell his client that he, Mr. Chikora, was not competent to handle the matter? Is that the basis for it?
That is the basis for it.
I don't think this is for disbarment. I think this is just for sanctions or I'm about to sneeze. No, I didn't. Suspension.
Yes, he should have been frank about that.
I could be wrong.
I think we even get to a subjective standard on that. This record just doesn't support any conclusion other than that Mr. Chikora had to know that he wasn't competent to represent a client in these circumstances, and he did so anyway.
Okay, well, let me just stop you there. Under the incompetence one, you say it's an objective standard, correct?
Yes.
But on 201, do you agree with me that we now need to get into a subjective standard that he actually knew?
It seems to be less objective than some of the other rules that we're talking about. 1.01A, for example, the competence rule. In this case, I think we easily we get beyond a pure objective standard. I don't think that we can go so far as to say that the commission's got to put on proof of somebody's state of mind other than putting on proof of the circumstances that existed like they did here, like we see in this record.
Would it be your position that there would be at least some evidence that he subjectively knew that he was incompetent?
Yes. Yes, I think that the facts speak loud and clear. You cannot reasonably reach another conclusion. And again, this is not an issue that was raised by the parties. This would be unassigned error. I haven't explored it in that detail, but yes, I think that we get there.
If for some reason, and let's say that this Mr. Kittner is unreasonable and persuades the rest of us that one of these charges, 101, 201, 301, perhaps, fails for some reason, what is your view on what happens then? Let's say we affirm on 3 out of 4 or 2 out of 4. What happens then?
The board has in the past and does have the authority to reverse part of the judgment, but still impose a sanction and then enter a new judgment. The board can do that. It's clear under the appellate rules and under your rules as well. The board's done that in several cases in the last few years. So you could do that, or the board could choose to remand the case for a new sanctions hearing. And in this case, if one of the findings, for example, there's been a lot of discussion about 2.01. If you reverse that finding, for example, we're still talking about the same underlying facts. You haven't found that any of the findings of fact aren't supported by the record. You will be finding that there's some legal issue, again, not raised by the parties, but some legal issue that you think is troubling here. We're talking about the same conduct. What you would be concluding, I guess, is that the commission applied too many rules to the same conduct. One of them didn't fit, but we're still talking about the same conduct. Really, the same or a very similar sanction is warranted. And there would be no reason to go back to the panel with that issue because no further development of the record would be needed.
In the past, it's as I recall, at least one instance, the commission and the party agreed that if the board were to reverse, that we wouldn't need to send it back to the panel because the parties would agree on a sanction. Is the sanction that's imposed here one that the commission would ultimately agree to, even if reversed on some ground or other?
Potentially. The same sanction that we have?
Yes.
Well, sure. Yes, the commission would agree to that. I don't know if
I was thinking yes was the right answer. But
Mr. Chikora might not, and I'm not sure what his feeling would be about that.
we'll ask. Thank you.
Okay, thank you.
Anybody else have any questions? Thank you, Ms. Hamilton. Mr. Paris?
Just briefly, and I know I only have a couple of minutes, so. Would the result have been any different, Ms. Jones, if Mr. Gonzalez, for example, Reed Gonzalez, the expert for the commission, had represented Mr. Hernandez? I doubt it. I don't think any lawyer could have obtained a ruling from the immigration judge granting a bond, for example, if the judge didn't want to grant a bond. We see that every day in criminal cases. In connection with...
Does that mean that Mr. Gonzalez would have been candid with Mr. Hernandez and told him, I can't do anything?
No, what it means is he would have said, he would have said exactly what he said in his testimony. It's a long shot, but here are some possible remedies. Let's pursue these possible remedies if you want. But it's a long shot. And that's what he says that he told him and the mother in his testimony. And we do that every day. I don't go in to guaranteeing, nor does any lawyer go in to guarantee a result for anybody. We don't, whatever these facts that come to us, we get saddled with. And if they're not good facts, we try to do the best we can with them. But giving the client the possibility of a long shot and saying, if you want to pursue this, fine, but it may not work, is not incompetence. And if you go, I think that the disciplinary prosecutor has to prove up their case by proving the elements of the rules. And in this particular competence matter, 1.01A, he would have had to prove that Chikura either didn't possess the knowledge, skill, or training reasonably necessary at the time of the acceptance of the representation, or that or because that's how competence is defined in terminology, or he would have had to prove that Chikura couldn't gone out and studied the immigration code and come by that competence or come by that knowledge.
Well,
that was not proved up.
You'd agree, wouldn't you, that I think you just said we can't, as lawyers, make up the facts.
That's right. And I don't think he made up any facts.
Would
I
you
think
agree that it would be a violation of 804 if he knew that Hernandez was not married but represented that he was? Would that be a violation?
If he knew it, but where's the proof that he knew it? The mother said he's been living with this woman in a common law relationship.
He's 18 years old.
And he said, well, you know, possibly if that's a common law marriage, and we might be able to go to the justice of the peace and get a certificate showing a common law marriage. That's what the suggestion was. It wasn't.
It can't be a common law marriage if he's 18 years old. Because you have to live, I don't know what it is in Texas. I think in Pennsylvania, you got to live together for 10 years. And then it can be a common law marriage. He's 18 years old. So even if he was living with a girl for 10 years, they were children. So that doesn't even count.
I know that you're not married, but we're going to say you're married. That is not in the transcript. There's nothing that constitutes a misrepresentation in the transcript. There's nothing deceitful, if you will, under 8.04A3.
But what about the representations that were made during the immigration hearing from the client, from the 18-year-old?
The client, what I understood those to be was the client said, he wants me to say I'm married and I'm not married. Something to that effect.
Right, but isn't that enough to show that in an effort?
Is there common law divorce then? Because I don't understand. Like you can just say you're married. You can just say you're married once and then boom, you're common law married. Because you can divide assets after that.
To mislead or some sort of artifact?
You know, I don't think so. If you are looking at it from a subjective point of view of Chikura saying, if you've been living together, holding each other out as being married and believing between yourself as you're married, then you're married. When he comes up there, the client comes up there in front of the immigration judge and says he wants me to say I'm married and I'm not married, and he admits he's not married. That's when Chikura withdraws, is fired, is terminated. He no longer represents him after that.
I mean,
so I don't think that's evidence that he lied to anybody.
Hernandez says he basically wanted me to say stuff that wasn't true. He wanted me basically to lie. That's the quote from the hearing.
And
isn't that the scintilla of evidence? Isn't that enough to say that an 8.04 violation is present? Given everything else? I mean, that to me is very troubling. I mean, I don't know how you get around that.
Well, I don't think that that is the way Chikura said the information.
I'm moving to Texas. Yes, I am. Because the next time there's adultery with me, I want the house. I want it. I want the whole thing.
That he gave down. He said, I understood from what I knew, based upon what the mother had told me, that these people had been living together. And if they've been living together in a common law relationship, then it could be a common law marriage. Now, we don't know whether the client was saying to the immigration judge, I'm not ceremoniously married or not. So I think there's a lot of wiggle room in there. And I don't think that you can
here's the trouble. If there's a lot of wiggle room in there, and this is on appeal, what's the standard?
Well, I don't think there's, the standard is set
If there's
forth
some
by-
evidence
Yeah,
from
but
which we can
it's a-
conclude that the panel got it right, don't we have to affirm?
if there's more than a scintilla of evidence, but in City of Keller and Keller versus City of Keller versus Wilson, the Supreme Court says a no evidence review cannot disregard contrary evidence showing witnesses were not qualified to give an opinion. And to the
Any
same
man.
extent, I think
Adultery?
you
I'm
can't
taking the house. Any man.
take into consideration something somebody said in a hearing when you have a live witness saying this is exactly what was said. So here, that's what we have from the standpoint of levels of admissibility or levels of evidence.
And same
Neither
question,
one of them.
same
neither one of
question I asked Ms. Hamilton earlier. If for some reason we don't buy all of the 01s, the 101, 201, 301, but you know, we buy 3 out of 4, 1 out of 4, and affirm on that basis, reverse on that basis, we send it back.
Here's my suggestion, Mr. Jones, that this be remanded to the evidentiary panel for a reassessment of the sanction, given the fact that the sanction isn't severed for each one of the individual counts.
And that's what my question was, is would
And I don't
your
think that
client
you-
agree to the same sanction, or are we going to have to send it back if that's the determination?
Well, we're not going to agree to the 3 years active, 2 years probated, not even with some prior discipline being used for enhancement purposes. And I think that since there is no assessment of discipline on each one of the counts, as opposed to a gross discipline for all of the accounts, you can't say which one weighed more heavily in the eyes of the panel members and which one did not. And so therefore it has to be remanded. That would be my answer. The only other thing I have, and I know I'm out of time. I've been out of town for a while, but I know Mr. Cruz asked about the malpractice situation. This is not a situation where we determine what a reasonable, prudent lawyer would have done under the same or similar circumstances. That's negligence. That's malpractice. The standard of care, if you will. He wasn't even charged with neglect under.
JK keeps adding dots. His anger is getting me.
101B, which is above the standard of care and constitutes conscious indifference that we all know about. So the reasonable, prudent standard that Ms. Hamilton has argued to you is not in any of these rules. There's no reasonable, prudent standard involving whether or not you're competent. There's no reasonable, prudent standard that embellishes upon whether or not you've given candid advice or whether or not you file something from a frivolous standpoint, outlandish legal theory, if you will. That is aside and apart and doesn't play a part in the disciplinary rules, in my opinion, Mr. Cruz. That's all I have. Thank you.
Anybody else have any questions? Thank you very much. We'll take this under advisement and issue our ruling later. Before we
Don't worry. We have an answer. See that little red box right there? Let's see what that means. Wait. Before we do, which you already did, I know. Practice areas, family, immigration. So he was an immigration attorney. He is not eligible to practice still to this day. If I was going to go to a Chikora, I would go to this Chikora. Only because I would like to pronounce his name anytime I have a question. I would say that entire name. Mr. or Mrs. I don't even know. Yeah. I just want to meet this person too. What do they? Okay, I guess they call him Catchy. Nope, I wouldn't call him Catchy. I would not. Nope. No. I am sick and tired of people changing their names so that Americans can pronounce them. No, your name is your name. You make Americans pronounce your name because that is your name. And you measure in grams and centimeters. You do that. Yes, yep, stuck like Chuck. All right, we did it. I had zero content ready for today. Zero. I had not even 1 minute of content ready for today. I thought, well, you know what? I'm just going to cheat and just play Judge Fleischer. So I put on Judge Fleischer, and that my whole cheat broke because there was no sound. But we did great for zero content. I thought we did great. I forgot to set up OJ. I thought about it 30 minutes ago, and I thought, oh, I have plenty of time. So I will set up OJ now, but you guys won't be automatically kicked over. It is getting, I can't say OJ is getting good, but it is anger inducing. It is so anger inducing. I just yell, scream, and swear every single OJ stream now. You know, I just start swearing right from the beginning to save time, because no matter how hard I try to get through a stream without swearing at them, I can't, because it's so bad. So I'm gonna take a few deep breaths before I get into OJ, because it's unbelievable. Thank you. Donald, if you can still hear me, keep your eyes on the damn road and make it to Tennessee, okay? And Terry, send your drugs. I mean, rest, relax, and recover. Actually, you know what? Rest, relax, and recover goes to a whole bunch of you. So can you guys just take it internally if you need those words? Thanks for coming. Oh my God, Rebecca, hi. Hi, Rebecca, hi. Oh, it's so good to see you. You don't even know. Like I have a drink of water after a long, long, long day outside. That's what happens when you posted something. I love you, Rebecca. Yeah, I'm being injured by OJ right now. I'm being traumatized. I don't even trust the law anymore, or judges or lawyers. Not that I did, but I really don't know. All right. Bye guys. See you really, really soon.
Got these life echoes, digital dreams. Through the screen, her blue eyes gleam. Wicked humor, sharp as a knife. Her stream sparks electric light. Late night when the world sleeps. turns gray. With a giggle, she lights the way. Kathy's life.